Good afternoon. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. With me here today is our CEO, Andrea Barton-Reeves, and our administrative and executive assistant, Amber Forrest. And the purpose of today's next hour is to give us an opportunity to share with you some information about the Connecticut Paid Leave Program and also talk about the changes to the Connecticut FMLA. So before I get into the meat of the presentation, however, I would like to thank Newtown and Monroe and the libraries for inviting us here today and turn the mic over to Beth Stoller, who will introduce the rest of the panelists.
Wonderful. Thank you very much, Erin. Good afternoon, everybody. I am Beth Stoller, and on behalf of the Monroe Chamber, I'm delighted to be here today with Helen Brookfield of the Newtown Chamber, and together we partner on a couple of different projects. And we are delighted to bring you this very important webinar so that we can all have a better understanding of what the Connecticut Paid Leave is all about. Here at the Monroe Chamber, we're always looking for ways to bring information and create enthusiasm within our local Monroe business community. We just completed a 2-week Monroe March Madness campaign that was a lot of fun. I'm especially proud of the Power Network Leads group that the Monroe and Newtown Chamber members are available to join, that we meet monthly. And lastly, the Monroe Chamber also is proud to co-sponsor about 8 to 10 lunch and learns annually with SCORE and the Edith Wheeler Memorial Library, who is one of our co-sponsors again today. So from the library, allow me to introduce Lorna Rines, the Executive Director, and she will share a few words about the Monroe Library. Lorna.
Hello, everybody. I'm so happy to be here today. And we have really enjoyed our partnership with the Chamber of Commerce and SCORE over the years. We've presented so many excellent workshops that Beth manages to organize for us. And they are still going on, although they have been Zoom. We are, in fact, open right now, but just for browsing and for computer use. But looking at the governor's recent orders, I'm hoping that in the near future, we're going to start having seating again, and maybe a little bit further out, start doing some in-house programming. Just before, or not too long before the big shutdown, we had set up a brand new business center with books for businesses. And if you're a self-employed person, we have all kinds of materials in there for you. Laminator, labeler, a supersized hole punch and stapler, and a shredder, and all kinds of packing materials and business books. So there's a nice little space in there. And, if you had a project that you were working on, you could certainly come in at this point and use some of that equipment. We also have faxing, and we are putting tables outside for outdoor Wi-Fi access in the nice weather. So we're doing our best to get things back open, and hoping that very soon we're going to be able to have people, coming to sit in the library and stay. Thank you.
When the chairs come back, the people will come back. I love it. Thanks, Lorna. Appreciate you sharing a little bit about what's going on at the Monroe Library.
Thank you.
Next, I'd like to introduce Helen Brookfield from the Newtown Chamber, my partner in crime.
Hi, everybody. First of all, thank you to the Connecticut Paid Leave staff for reaching out to us. We've been working hard to stay in front of the information for our small businesses. And I want to congratulate the state, all the state agencies, on really stepping up their game as to the communication and the outreach. And I hope that is the new normal. Obviously, I advocate for small businesses, and small businesses have been doing extraordinary things these past 12, 14 months. And I can't say enough how we need to appreciate, how they've been in it. They've been in it for us, and really extraordinary. I just want to remind you that a small business owner is never guaranteed a paycheck. We need to get open so people come out so we can keep going. But I just love doing these programs together, and I hope that this is something we can do going forward. Thank you.
Great. And I guess now we will turn it back over to Erin.
Thank you so much. I'm going to go ahead and share my screen so that we can get into the PowerPoint slides, which we will be able to share with you after the program today.
We can see your screen, Erin.
Great, thank you. So as I said, I am the General Counsel for the Connecticut Paid Leave Authority, and I'm skipping over the picture because that is a pre-pandemic picture. It doesn't look like me anymore, but I have been working with the state for over 15 years and have been working in employment law for over 20 years with a focus on FMLA, both from the employer side, from HR side, and now with the authority in trying to stand up the paid leave program. We have a lot of information to share, so I'm just going to jump straight in. We're going to talk about the paid leave program. We're going to talk about the various leave laws that already exist and then the changes to the Connecticut FMLA. And then we'll focus on the role of the employer in terms of what these laws mean to the employers. And then we'll discuss a little bit about how employees will apply for paid leave benefits. We can talk about the private plan option as well as how to register if you haven't registered already. And then we'll share some additional resources, making sure we leave time for questions. So I will talk quickly. If you have questions, please put them into the Q&A function, and Amber will be able to moderate that so we make sure we address all the questions. The Paid Leave Authority is a quasi-public agency, which means that we were created by statute, Public Act 19-25, and so we're a state entity. Our purpose is to stand up the paid leave program, which will enable employees who need to take time away from work because of their own serious health condition or to care for a family member, be able to do so without jeopardizing their economics and income by giving them access to paid leave benefits. We are also responsible for helping ensure that employers understand their role in this law, helping make sure that they know what they are supposed to do and what their opportunities are. We have a statutory responsibility to perform outreach and engagement, which is why we really appreciate opportunities like today to speak with the chambers. We also have to set up the program. It's brand new, so we had to stand up the agency, create all of our policies and procedures. The statute says that the paid leave program is funded entirely by employees. And the way that's done is through a 0.5% contribution from employees. That 0.5% is the cap. If in the future our reserves are solid enough, we may be able to reduce that amount. And so that's something that the authority will pay attention to. But right now we've got the 0.5%, and our responsibility is to receive those contributions. And as I mentioned, we also have this private plan option, which we administer. And then starting in January of 2022, which is really just around the corner, we will start administering claims for paid leave benefits. Just a quick highlight of the things we've been doing lately. We stood up our website in September, and we opened the employer registration in November. So we want employers to register with the CT Paid Leave Authority to create their accounts so that they have a place to go when they need to make their contributions, and to provide us with the information we need to be able to communicate effectively with the employers. Per the statute, the obligation to begin taking the deductions started in January of 2021. So that's when employers were supposed to begin deducting that 0.5% from the employee's wages. And those deductions or contributions are to be remitted to the authority on a quarterly basis. To be consistent with the Department of Labor and Department of Revenue Services, we actually give every employer a 1-month grace period. So as long as the contributions are received by the authority by April 30th for the first quarter, they are on time. We've also been reviewing private plan applications. Right now, we're pivoting toward the claims administration process, and we plan to have that claims administration process set up so that employees, as well as sole proprietors and self-employed individuals who have registered for the program, can start submitting applications for benefits in December. That's the goal. by statute, we need to be able to start paying income replacement benefit claims by January. So let's talk about the paid leave program. Who is covered is the first question we always get asked. So that's why we try and address it up front. It's almost everybody. Employers who have one or more employees working in Connecticut are, by statute, covered. Therefore, their employees must contribute to the plan. This includes nonprofits. It also includes private sector employers with unionized workforces. It also includes, as an option, sole proprietors or other self-employed individuals who choose to opt in. Sole proprietors and self-employed individuals are not required to participate, but if they choose to, they can enroll, but they have to stay in the plan for 3 years. By statute, there are some employers who are excluded, and that includes the federal government and other sovereign territories like the tribal nations, the state of Connecticut, except as to covered public employees. Municipalities and local or regional boards of education are excluded unless they have covered public employees. And non-public elementary and secondary schools are also excluded, meaning their employees do not remit the contributions and will not be able to apply for benefits from the authority. Covered public employee is defined in our statute as well. So, as I said, the state and towns and boards of education are excluded except for covered public employees, meaning covered public employees do participate, we do remit contributions, and we'll be able to apply for benefits. And so a covered public employee is a non-unionized employee of the state, so managers and appointed officials and elected officials. Unionized employees of the state who collectively bargain to be included, and then employees of municipalities or boards of education will be considered covered if the unionized employee of that town or board collectively bargain to be included. So there's an opportunity through collective bargaining if they want to participate. As I mentioned, one of our responsibilities is to manage the contributions. So the contributions are 0.5% of your employee's wages. We calculate the wages for purposes of contribution using the FICA number. So whatever number you're using for purposes of making your employees FICA payments, so Social Security, I think it's box 3 on their W-2. That's the number you use when you determine what the 0.5% is. And the reason we use that number is because by statute, contributions are capped at the Social Security contribution limit, which is currently about $142,000. So employees are responsible for making the contributions, but the employer is the one who's handling the payroll. So the employer's role is to actually take that contribution and remit that contribution with some very minimal wage information to the paid leave authority on a quarterly basis. So they take it every paycheck, they remit it on a quarterly basis. We receive the contributions and they're immediately deposited into a paid leave trust, which is administered by the state treasurer. Although the trust is not actually a state account, it cannot be used for any purposes other than to manage the program and fund the benefits. Okay. So that's a little bit about the authority and what we've been doing. Let's talk about how this really impacts employers and employees. And I think the best way to do that is to understand the context of how the Connecticut Paid Leave Act fits into the existing universe. We have several laws in Connecticut that provide job protected leave, or at least an opportunity for job protected leave. And that includes the federal FMLA, which applies to employers with 50 or more employees, as well as the Connecticut FMLA, workers' compensation, as well as the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act. Now, these last 3 laws that I mentioned provide that leave, job protected leave, may be a reasonable accommodation to individuals who need time away from work as a reasonable accommodation. So it's not a guaranteed right to job protection, but it is something that has to be considered. at least for their own serious health condition or pregnancy, as the case may be. Other than workers' comp, however, we really have not had any laws that guarantee income replacement during leave up until now. And the Connecticut Paid Leave Act is that change. Connecticut Paid Leave Act, starting in January of 2022, will provide eligible employees with income replacement if they need time away from work. You'll note on the slide that I've highlighted the difference between Connecticut FMLA before January 1, 2022 and after January 1, 2022. And that's because Connecticut FMLA is going to undergo a major change on January 1st, 2022. Right now, Connecticut FMLA only applies to employers with 75 or more employees. So many employers have never had to deal with it. And if you have had to deal with it, you've only given job protected leave to your employees who've worked for you for at least a year and have 1,000 hours in the 12 months immediately preceding their leave. And if they're eligible, they can get 16 weeks of leave in a 24-month period with a separate entitlement of 26 weeks for military caregiver leave. In January of 2022, that's going to change significantly. First, Connecticut FMLA will apply to all employers with one or more employees, with those same statutory exemptions I mentioned for Connecticut Paid Leave Act. Now, with those employers with one or more employees, their employees will be eligible for job protection after 3 months instead of the year. The amount of leave will change too. It will be 12 weeks in a 12-month period. There's still an availability for military caregiver leave, but there's a new entitlement, which is an additional 2 weeks of leave for incapacitation during pregnancy. The other change to Connecticut FMLA relates to when employers can require their employees to use their accrued time off. Right now, an employer could require an employee to use all of their accrued time off while they're out on leave, and they could exhaust all their PTO. But as of next year, employers could still require employees to use their accruals, but you have to let them hold on to at least 2 weeks instead of making them exhaust all that time. For both Connecticut Paid Leave Act and the Connecticut FMLA, you have to have a qualifying reason in order to receive job protection or the benefits. And these reasons are the same for both laws. They're to create or expand your family, either with the birth of a child, the placement of a child with you for adoption or foster care, which we call bonding leave. You can also take leave to care for a family member with a serious health condition, which is usually referred to as caregiver leave. You can, of course, take leave to care for yourself if you have a serious health condition. And the definition of serious health condition includes not just things you might normally think of, like a serious injury or an illness. It also includes serving as an organ or bone marrow donor or pregnancy. There's something called military caregiver leave, which I alluded to, and that's leave to care for a family member who's injured on active duty while in the military. There's something else called qualifying exigency leave. That's available to employees if their parent, spouse, or adult child is called to overseas active duty. And there are specific reasons where you could take leave in that circumstance. Finally, Connecticut law provides something called family violence leave. That is leave that is available if you are experiencing family violence and you need to relocate or go to court or receive treatment or counseling. The caregiver leave is something that I want to highlight because the Connecticut FMLA and the Connecticut Paid Leave Act allow for a much broader definition of caregiver leave than the federal FMLA or the old Connecticut FMLA. Under federal FMLA and the old Connecticut FMLA, you could only take caregiver leave for your parent, spouse, or child under 18, or a child who is 18 and over, who has a disability as defined by the ADA, which prevents that child from engaging in 3 or more activities of daily living. So it's a pretty high burden to meet. Under the new Connecticut laws, you can take caregiver leave and receive income replacement benefits when you have to take time away from work to care for your parent or spouse, or a son or daughter of any age, or your sibling, grandparent, grandchild, or an individual who's related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of one of those family relationships. It's a lot to unpack, so let's just take the highlights for a second. New FMLA, new paid leave, it's a child of any age, so you don't have to worry about that 18 and over stuff, and it could include your siblings, grandparents, and grandchildren. Or it includes this affinity relationship. Related by affinity is a concept that's new to Connecticut, but is not new to the federal government. Actually, the federal government has been using this definition for about 20 years in its bereavement leave and federal contractor sick leave and other such provisions. Basically, it's a recognition that families don't look like Ozzie and Harriet Nelson, or even the Keatons, or the Huxtables. You know, it's people may create their own families, and it may not be that nuclear family you would have expected to see based on public media. So it could be someone who is equivalent to a parent, spouse, or child, or grandparent or sibling. For example, in my family, my great aunt really stood in the place of my grandmother. My grandmother passed away when I was 3, but my great aunt was always there. And as she got older, we were the ones taking care of her, getting her groceries, doing her laundry. When she broke her hip, we were the ones taking care of her. Under the new law, I would be able to take family leave for her because she was the equivalent of my grandmother. Similarly, in Connecticut, we don't have a common law marriage statute. So if you're not married, you're not related under Connecticut law. But under Connecticut FMLA and the Paid Leave Act, if you have an unmarried significant other with whom you maintain a household and a family-like relationship, even though you're not married, you could take leave under the new FMLA and get benefits for it. Okay, just a couple other kind of high-level things to understand about the leave. There's that federal FMLA, Connecticut FMLA, both provide job-protected leave. And they both provide up to 12 weeks of leave in a 12-month period for eligible employees. With that exception of that 26 weeks of caregiver leave. Connecticut FMLA is different because it does provide that 12 days can be used for family violence leave and allows for that 2 additional weeks of incapacity. And as I mentioned, you can get income replacement for 12 weeks in a 12-month period for all leave reasons, including military caregiver, as well as the 2 additional weeks for income replacement for incapacity during pregnancy, and the 12 days that can be used for family violence. So even though the amount of leave looks relatively similar across the 3 laws, the eligibility requirements are actually very different, which is going to involve a little bit of challenge for employers, candidly, because you have to juggle the 3 different, you have to be aware of the 3 different laws and juggle the 2 different job protected leave entitlements. To be eligible for federal FMLA, you have to work for an employer with 50 or more employees, and you yourself have to work for that employer for at least 12 months and have worked at least 1,250 hours in the 12 months immediately preceding leave. Under the new Connecticut FMLA, as I mentioned, you only have to work for the employer for 3 months, and then you'll be eligible for job protected leave. To be eligible for income replacement benefits under the Connecticut Paid Leave Act, we don't look at how long you've been employed with any particular employer. We look at how much money you've been earning while working in Connecticut. So if you've earned at least $2,325 in the highest earning quarter, when we look at the first 4 of the 5 quarters before you apply to us, you'll be eligible for leave, or eligible for income replacement, as long as you are either currently employed or you had been employed in the 12 weeks before applying to us. When we look at the 23-25, we're going to be using Department of Labor data to help determine if you've made that threshold. And the reason we're using that data is because the statute says the earnings may be combined from more than one employer. So if you have employees who maybe work part-time, they may not earn 23-25 from you, but if you add up all of their jobs, they will have hit that eligibility. Okay, so what do you as the employer have to do in connection with these laws? really the questions that you ask are the same as the questions you're probably asking right now. The answers might be a little bit different though. Anytime an employee asks for time off from work for a potentially qualifying reason, so one of those that I listed, you should be asking, is this employee eligible for job protected leave under one or more statutes? Am I required to provide this employee with job protection when they take time off? And the other question is this employee eligible for any income replacement while they're out of work? You're asking those questions right now, most likely when someone comes to you and says, I need hip replacement, or I need to go take care of my dad who's having heart surgery. But you need to be a little bit more methodical about it, because you need to think about, are there any statutory entitlements? An employee could be eligible for federal FMLA only, Connecticut FMLA only, federal and Connecticut FMLA, in which case the leave would run concurrently. And I have an example to show that. Maybe they're not eligible for FMLA at all, but job protected leave would be a reasonable accommodation to them under the ADA, the Pregnancy Disability Act, or CFPA. And some employees won't be eligible for any job protected leave whatsoever. That's not the end of the scenario though. You also need to think about, what do I offer as an employer to my employee for paid time off? Do we have sick leave policies? Do we have vacation policies? Do I offer short-term or long-term disability benefits? The Connecticut paid leave statute says that an employee could receive benefits from both the paid leave authority and the employer at the same time, as long as the total amount does not exceed 100% of the employee's wages. Short-term and long-term disability policies are policies that are sold by insurance companies, so you really need to look at the language in those policies. But generally speaking, most of them say you need to use an employer-provided time off, like accruals, or state-provided paid time off before an employee could access that benefit from the policy. So you need to look at that. I should note that our statute says that an employee who's receiving workers' comp cannot get benefits from the paid leave authority. It's a straight up bar. As I mentioned, an employee may not be eligible for job protected leave under the statutes, but they still need to come to the paid leave authority to determine if they're eligible for income replacement benefits through the Paid Leave Act, because those eligibility standards are different. The Connecticut Paid Leave Authority makes a decision about who's eligible for income replacement benefits, not the employer, unless the employer has an approved private plan, in which case the employer said, I am offering this private plan that is as good or better than what the state will offer, and I will stand in the shoes of the state in making these decisions. All right, so employee comes to the employer and says, I need job protected time away from work. You as the employer consider their entitlements under federal FMLA and Connecticut FMLA and the other statutes and make your decision. Yes, you're entitled to job protected leave, or no, you're not. Regardless of what the employer decides, the employee can still come to the paid leave authority and says, I can't work because of a qualifying reason. Can I please receive income replacement benefits? They'll apply to us. We will validate that they're eligible and that the reason qualifies, and we'll calculate the benefit amount. We do need to communicate with the employee and the employer. The statute actually says the employee has to notify the employer if they're applying to us. And we need to validate their absences, when they start and return, and we need to determine if there are any employer-provided benefits that would offset against the benefit we provide. And then we issue the benefit payments. I keep saying we're actually working with a third-party administrator to handle this part of the work. Benefits are set forth in statute, and they're based on how much the employee earns. So if an employee earns less than or equal to the Connecticut minimum wage times 40, their benefit will be 95% of their base weekly earnings. If they earn more than the Connecticut minimum wage times 40, their benefit will be that Connecticut minimum wage times 40 plus 60% of the difference between what they earn and the Connecticut minimum wage times 40. However, the total benefit in all circumstances is capped at 60 times the Connecticut minimum wage. We just have a couple of examples here because I think it's easier to see it when the numbers are included. So Mike earns $375. That's less than the Connecticut minimum wage times 40. So Mike would receive 95% of that weekly wage in benefits. Deborah, on the other hand, earns $700 a week, which is more than 40 times the Connecticut minimum wage. So we would give Deborah the $480 plus 60% of the difference between 700 and 480. So Deborah's income replacement benefit would be $612. If Deborah earned more than that, say she earns $1,000 a week, she would be capped at 60 times the Connecticut minimum wage. All right, I have been going really fast to try and get you a lot of information in a short amount of time, but let me give you an example of how this may work in real life or in the world of Warner Brothers cartoons. So Acme Industries has 100 employees working in Connecticut. Wile E. Coyote has been working at Acme for 10 years. He's got 4 weeks of sick time and 2 weeks of vacation when he injures himself in a non-work related incident and has to be out for 8 weeks. Acme, as the employer, needs to say, all right, is Wiley eligible for any job protected leave? And is he eligible for income replacement benefits? So let's see what that looks like. Because Wiley's worked for Acme for more than 3 months, he's definitely eligible for Connecticut FMLA. And we're going to assume that Wiley, as a full-time employee, has made the 1,250 hours needed for federal FMLA. We're also going to assume he's made the 2325 in his highest earning quarter needed for Connecticut paid leave benefits. So Acme requires its employees to use their sick time when they're out on leave for their own serious health condition. So on Wiley's first day out, his Connecticut FMLA will start, his federal FMLA will start, and he'll receive income replacement using those 4 weeks of sick leave accruals. When he uses up the 4 weeks of sick leave accruals, he still needs to be out of work for 4 more weeks, which he's able to do because he's still got that time under Connecticut and federal FMLA. And that's when he'll start receiving wage replacement benefits from the Paid Leave Authority. Another example would be for a smaller employer with only 20 employees, and Jamie is a part-time employee who's worked there for 2 years. When she breaks her leg, she's got a couple weeks of sick leave and a couple weeks of vacation. So same analysis. What job protection is available to her, and what income replacement can she utilize so she can still pay her bills while she's out of work? Again, we're going to assume that Bionics R Us requires their employees to use their accruals with that 2-week exception that is required by statute. Jamie is eligible for Connecticut FMLA because she's worked there for more than 3 months. She can't take federal FMLA because her employer is too small. There's not 50 employees. So Jamie's Connecticut FMLA will start the first day she's out of work. Her sick leave will be available to her for those first 2 weeks. And then she can also use 1 week of vacation, and leaving 2 weeks of vacation available to her for other purposes. And then she could apply to wage for benefits from the Paid Leave Authority starting in week 3. You'll note that because she's a part-time worker, each week is the 3 days. So that's how we would calculate her week. If the employer did not require the employees to use their paid time off, the employee could apply for wage replacement benefits as soon as they go out of work. I do caution employers to think clearly about whether that's the best approach to use with their staff, because that means the employer is allowing the employee to hold on to paid time off, which could mean that they have extended job protection even beyond the statutory limits, because they have the right to use those accruals before they would be terminated. There are some tricky rules relating to when spouses work for the same employer. Basically, under the federal FMLA, The spouses share their 12 weeks if they're bonding with a new child or to care for a parent with a serious health condition. Under Connecticut FMLA, they would share those 12 weeks to bond or to care for any family member. But under Connecticut Paid Leave Act, the spouses are not required to share their entitlement to income replacement. So that may be a situation where you have spouses who both work for you. One of them says, I'm going to take the job protection. I'll get all 12 weeks. The other one says, I'll forego the job protection, even if I lose my job, but I can still get income replacement. All right, I want to make sure we have time for questions. So I'm just going to jump through private plans and say, if you have an interest in administering your own private plan option, it's something that's available to you. You have to get approval from the Paid Leave Authority. And there's a website, there's a page on our website called I Want to Apply for a Private Plan that has all the information about how to apply. You need to have a plan that is either from an insurance company that's been approved to offer a paid family medical leave. We have the list of them on our website, or a self-insured plan that follows the guidelines that we set forth. Before I go to questions, I want to make sure that every employer knows that they need to register their business and we know how to do so. So please register. If you don't register, we don't know that you're supposed to be remitting those contributions. And when you remit those contributions, we won't be able to assign them to your business. So you want to make sure you're registered. If you have registered, but you haven't been able to start, or you were not able to start deducting the contributions in January, you've got some time. You have until the end of June to collect those missed contributions by taking an additional deduction from your employees' wages up to 1% to catch up those missed contributions that you didn't take earlier in the quarter. But you do need to register and you do need to start taking those contributions, because the grace period will end, and in the future, if it turns out that an employer has not been responsible and has not done the contribution deductions and remittances, the employer could be fined or otherwise penalized for not complying with the law. To register, you would go to our website at ctpaidleave.org and click on the Register Your Business button, and we'll walk you through. The first thing you have to do is actually create an account with ct.gov. So we'll send you to their website, business.ct.gov, if you haven't done so. And then once you get those credentials, you come back and you fill out the minimal information we require for you to register with us. All right. I've given you a lot of information, and I know that when you get out of this hour, you're going to say, what did she say? So if you go to ctpaidleave.org, check us out. We have an employer page. We have an employee page. There's an employer toolkit that includes links to a poster, rack cards, mailers, fact sheets, videos. All of our printable resources are in black and white and color and in English and Spanish to try and make it as easy as possible for you to explain to your employees what's going on. ctpaidleave.org. Bookmark it, come back frequently, make us one of your favorites. We have a lot of information there, not just on the law, but on the practical details about how to register, how to remit your contributions. We've got links to videos and frequently asked questions. So we encourage you to check it out. Okay, again, register. If you have third-party payroll providers, make sure that they're processing it for you. They should be. We've been dealing with them for a year now. And share this information with your employees and check back frequently, because we keep adding more stuff to our website. All right, I'm going to stop sharing my screen because I've been seeing questions, the question tab coming in, but I don't know what the questions are. Amber, can you help facilitate
Absolutely.
this?
Thanks, Erin. Okay, so I'm going to start at the bottom so you can keep up with me. What information will the Connecticut Paid Leave Authority ask from the employer, and what information will be needed from the employer? And I think this is in regards to the affinity.
You think it's in regard to affinity?
Yes, the documenting of affinity. What the definition
Okay,
of
so
family
with the documenting of affinity, we'll be dealing with the employee, and we'll be asking the employee to provide documentation to substantiate the claim that the person is meets the standards. We're actually working with the Department of Labor because it's the same definition for the job protection and for the income replacement. We want to make sure that we're being consistent so that the specifics about what that documentation are will be we'll be getting out to employers sometime in the next few months once we finalize that with the Department of Labor.
Okay. And how will this work for temporary employees? For example, someone that might only be working for a company for 6 months.
So for income replacement, a temporary employee is considered to be an employee and could apply to us for income replacement benefits as long as they've earned the 23-25 in their highest earning quarter. In terms of job protection, the first question is who employs the temporary employee? Is the temp employed by the business or is the temp employed by a temporary agency? If the temp is employed by the business, then that temporary employee is entitled to job protection, but not beyond the scope of their original contract.
Okay. And what if an employer initially reports to Connecticut Paid Leave that an employee didn't receive any pay while out of work, but then later the employer is approved 100% to pay through employer STD?
So we recognize that over the life of a absence, an employee's status in terms of what other income replacement they receive may change. So we're working with a third-party administrator to make sure that we get up-to-date information. Certainly, there may need to be some reconciliation if an employee receives benefits from us and then later receives benefits from some other source that would bring them over 100%. So that's why we're going to be working to make sure we have up-to-date information about other sources of income.
Okay. And I believe we answered that one already. When will an application for paid family medical leave be on the website? I know a lot of people have been asking us this.
So we are trying to make sure that people understand that the benefits are not going to be available till January of 2022. So we don't want people applying now thinking they're going to get benefits now. Our goal is to be able to open up the application process by December.
Okay. Let's see. And what is the time frame between in which an employee has to file for paid leave benefits?
Great question. That's something we're still working through right now, but we generally follow the federal regulations about FMLA because we want to make sure that it's as consistent as possible with FMLA. And so that usually is 30 days in advance for a foreseeable absence. If you know, for example, that you're due in May, we want to know at least a month before the baby's due. Or if you know you have surgery that's scheduled for the end of the summer, we'd want to have 30 days in advance. And that would be true for FMLA as well. If it's not foreseeable, someone comes down with pneumonia, we would need to know as soon as practicable.
Okay. And the next question is, ADP has not yet filed for our company. Is there a grace period?
So we are in very close communication with all the payroll providers, and we know that they have been in uploading their registrations and contributions in batch basis. So, you can always check in with them. We would never tell you not to check in with them, but the grace period for remitting contributions ends on April 30th, and ADP knows that.
Okay. And we actually have a couple of questions regarding the residency. What happens to remote workers that live in Connecticut, work in New York, now are working remotely from home in Connecticut?
Great question. It's It's definitely a question I don't think people were thinking about when they passed the law, but it's something we've been thinking about for the past year. And we're following basically the unemployment insurance guidelines. So if you normally work in New York, and there's every expectation that you're going to go back to work in New York once the pandemic restrictions are lifted, your employer has been paying into New York unemployment for you, so you would be covered by the New York paid leave program instead of ours. On the other hand, if your employer has really shifted and said, we're not bringing anybody back to New York and everyone's going to permanently work from their homes, your employer would be notifying both New York and Connecticut, and we would expect that they would participate in the Connecticut unemployment and would participate in the Connecticut paid leave.
Okay. And in regards to that same question, what if the employee is a statutory employee?
So I'm not entirely sure what they mean by statutory employee. So maybe they can give us a little bit more information.
Okay. And will the state reduce an individual's Connecticut paid leave benefit by the amount an employee receives from their employer?
Yes. So if the employer, for example, has sort of paid leave program, some employers will give you 50%, for example, then that would be offset against the benefit that we would provide. As I mentioned, an employee can receive benefits from both the employer, and the paid leave program, as long as the total do not exceed 100%. So we just have to look and see kind of what the offset would be.
Okay. And for 2022 Connecticut Family Medical Leave, is there any working or earning requirements for eligibility at all now that the hours worked and the 12-month provision is eliminated?
I am having trouble following that question. Is this the one that came in at 1223?
Yes.
Okay. So for job protected leave starting in 2022, it will simply be the 3 months. There will no longer be an hours worked requirement. You just have to show that you worked for 3 months. And there's no earning requirement associated with job protected leave under Connecticut FMLA. The earning requirement is associated with income replacement through the Connecticut Paid Leave Act.
Okay. Again, this one is on residency. We're based in Florida and have one employee working in Connecticut. We registered with the state last week when we were made aware of the regulation. The employee will begin deductions in the current payroll. We have to backdate her contributions.
So you would be an employer who would want to take advantage of that catch-up deduction that we're allowing through the Department of Labor, actually, which handles wage and hour law and deductions, is allowing. And so what you could do pursuant to that catch-up period is take catch-up deductions so that you could take an additional up to 1% from your employee's paycheck to be able to make sure that by the end of June, the employee is all caught up with the contributions.
Okay. And I might need your help with this one a little bit, Erin. This is the one that came in at 1219. Why must an owner, employee of a PC, have to participate where the owner is the only employee? So I'm thinking sole proprietor. Also, if the only employee is collected by Social Security due to age, would he or she be exempt?
Okay, so two separate questions. The first is, if you set up your business so that you are receiving a W-2, you are set up as an employee. And so by statute, you're an employee and you have to participate. If you are not receiving a W-2, you're not considered to be an employee. So we're just being consistent with the tax, sort of the definition of employee as set forth under the tax code. So if you are an employee, you would participate in that, even if you're the only employee. In terms of an individual who's collecting Social Security, we would certainly not take contributions from the Social Security benefits, but if that person is also receiving wages, then the employee would have to contribute out of those wages up to the Social Security contribution max, which is, as I said, 142,000. So you're not exempt because you're old enough to receive Social Security, because you're still earning wages.
Okay. And is there a way that our business can check if the authority has received their payments from the payroll company?
So, I think that you can, but I'm not 100% positive. So either Andrea or Amber, if either of you have better information than I do, my belief is that when you go in and if you've registered already and it should reference, and the benefits have been, I'm sorry, if the contributions have been paid, that will be reflected in your account. Is that correct, Andrea?
That's correct. So if you've registered, then there should be a function that's called My Account. So when you go onto the website, and if you have already registered, you should have a login and an ID and a password that you can use that you would use on the site. You would log into the site and it would take you to My Account as one of the drop-down choices. And then you can see all of the activity on your account, which would include any payments that have been made. If you're using a third-party administrator and they're supposed to be submitting your payments on your behalf, you should also see it there, but if you don't, you should contact the third-party administrator directly because they pay it in a different way. They actually kind of aggregate all of their clients and pay it all at once. So it takes a little bit longer for it to register with each individual employer that they represent.
Thank you, Andrea.
Thank you, Andrea. And I have dropped a link in the chat for you with the My Account link. So if you click on that link there, that will take you to where you can access your account. All right, Erin, scrolling back down to the bottom, coming in at 1254. If you are a staffing firm providing temporary hourly workers to different clients for a contracted period, under these circumstances, I am assuming the staffing firm would not have to guarantee job protection. Is this correct?
So I'm not going to be able to answer that question definitively because there are just so many different provisions and considerations associated, and so many different permutations, frankly, of the way temporary agencies work. So I think the best thing to do would be to talk to your own employment lawyer, because it really depends on whether those workers are already set up for you as your own employees, or if you're sort of acting more as their agent. So I really think that's a question you should talk to your employment counsel about.
Okay. And if the employee qualifies for paid leave under both an employer's plan and the Connecticut plan, is the employer's plan considered the primary payer, or with the state being the secondary payer as far as coordination of benefits?
So so there's two ways to interpret this question. So I'm going to give you both interpretations and then I'll answer both questions. If the employer has an approved private plan, that means that they're providing a paid family and medical leave plan to their employees, and their employees will not participate in the Connecticut paid leave program at all. So that employer approved private plan is the only payer. On the other hand, if you're talking about a short-term or long-term disability benefit that's offered, which would not be equivalent to a private plan, it really depends on the language in that short-term or long-term disability policy. But most often, what we've seen is that those policies would make the state the primary and the short-term or long-term disability would be the secondary.
Okay, thank you, Erin. And how will an employer know if an employee has used their 12 weeks of Connecticut paid leave entitlement?
So we would be, as I said, communicating with the employee and the employer relating to an employee's claim for income replacement benefits through the Connecticut Paid Leave Act.
Okay. And if an employee works for more than one employer, who determines if the $2,325 has been met to figure out if the employee is eligible for paid leave?
Right. So that's the responsibility of the Paid Leave Authority. And we have access to Department of Labor information, so we can see the income that the employee is receiving from multiple employers.
Okay, and will the employer be notified when an employee has been approved for Connecticut paid
Yes.
leave?
Yep.
Great. How will the Connecticut Paid Leave Authority pay intermittent income replacement?
Yeah, so intermittent leave is really an interesting situation because employees can take leave, for weeks at a time, or maybe they just take it, in small little increments or on an intermittent basis. So we're working with our third-party administrator right now on that question, but basically, we're not going to be paying it in like a 15-minute or half-hour absence. We're not going to send a check out for each of those absences. We're going to have the administrator sort of aggregate it to us when we're still working out the exact, if it's going to be how many hours they have to be out before they get a check. But we're basically bundling it up and then issue one check per bundle.
Okay. And at the moment, we're down to our last question. We have a couple of benefits leaves administrators administering a private plan. And our leave should run concurrent, so there will be an offset to the employees paid by the company. Is the company able to view employees who enroll for these benefits, the approved letter, as well as the benefit amount they received?
Yeah, so again, I'm assuming this question, they're talking about a short-term or long-term disability policy, because if you have a private plan, then that's either an approved private paid family medical leave plan or the Connecticut program. But if you're talking about short-term or long-term, we would be in communication with the employee and the employer to make determinations about what offsets are applicable so that the calculations are correct. So we would be communicating sort of
Okay.
through the life of the claim.
All right, thank you, Erin. That concludes our questions at the moment, and we're right at 1 o'clock. I just wanted to let our participants know I have some helpful chats in the chat box. So if you want to check those out, that would be great. And Erin, I'm going to pass it off to you.
Great, thank you so much for having us here. We will share the slide deck and the recordings once they're available with Beth and Helen and Lorna so that they can share it with all of you. This is also recorded as well as other recordings that can be available on the CT Paid Leave Authority's YouTube page. So we will, I think typically we get them out to you within the week, right, Amber?
Usually about 2 days.
Okay. All right, well, thank you all very much. As I said, check us out, ctpaidleave.org. Register if you haven't registered, get those contributions in, and be on the lookout. We're developing more content and more training as we move from spring into summer, so we can help people get ready for these new programs.
Thank you. Thank you.
All right, thank you, everyone. Have a great day.
Thank you.
Thank you.